I would first want to introduce our next speaker, Sean Foreman, from the firm of Wickwire Holmes here in Halifax, who's going to speak to creative sentencing issues from the corporate perspective as counsel. I'd also like to remind people, as we did mention at the outset, Judge Curran, who is due to speak in this session, is unavoidably not here due to illness, and we are sorry for his absence and trust that all will be well. We will also be taking questions again from the floor as before. We will repeat the question for the online participants, and I think Sean is happy if anybody should interrupt during, then I'll ask him to summarize the question that he receives from that purpose. Otherwise, we'll also be taking the questions afterwards and proceed on that basis. Is there anything else the organizers needed announced at this point? Nope. Okay. Turn it over to you, Sean.
Great. Thank you, Phil. Morning, everyone. Those of you from out west, welcome to a bright sunny day in Halifax, and it's almost 10 degrees, so it's practically spring. And also, as Phil and I discussed when I came in just a short while ago, thankfully today's session is not during the Olympic gold hockey game in the morning, otherwise I expect I'd be here speaking to myself. Being one of those strange people who is not a hockey fan, yet happily living in Canada for 24 years. I'm here and was invited to speak about the corporate perspective with negotiated sentencing. And I'll start by just giving you a brief intro of my background and experience that kind of informs the perspective that I'm going to discuss with you. I have no magical PowerPoint presentation this morning. I am rebelling against the use of PowerPoint. You have my lilting Irish and British tones to listen to, and I will do my best to... do we have still the full amount of time, Phil, that was originally scheduled? As much time as we need? Okay. Great, okay. So I'll start with a brief introduction of my background and experience. I'll move into the meat and potatoes and this very interesting and important topic of negotiated sentencing. I'm going to spend some time discussing the Syncrude decision, as I think that's very instructive when we look at the corporate perspective. Obviously, from a corporate perspective, I think, and I teach business and environmental law here at the law school, and many students come into the class thinking that money and financial issues are it for business and for corporate interests. And after you've heard me speak, whether you know that already, that's clearly not the case. And then I'll just wrap up with some conclusions on kind of the pros and cons and my thoughts on the topic. I'm a partner at Wickwire Holmes, as Phil said. I've been a business lawyer essentially for 15 years. I did my specialization here at Dalhousie in environmental law. As I said, I teach business and environmental law. It's a paper seminar class. Been teaching that for 7 years. Keeps me on my toes. I'm past chair of the CBA's National Environment Energy Resource section, provincially and federally. I've worked with business through the CME, Nova Scotia, Canadian Manufacturers and Exporters, was chair of their Environment Committee for a couple of years. Most importantly, my client work. I deal with every kind of business, from sole proprietors, small businesses, to small corporate, privately held companies, up to the largest multinationals. Many people don't realize, as an example, that BHP Billiton, the largest mining company in the world, multi-billion-dollar organization, actually has an operation here in Nova Scotia, the old East Campbell mine down in Yarmouth County. It's a closed mine, very active, multi-million-dollar remediation. I've been working with them for many years. We have lots of interesting issues. So my experience runs that gamut from kind of the small to the large in corporate interest. And I think, therefore, it's fair to say, starting out, that there's no homogeneous kind of perspective with respect to business and corporate interests in this area, as with any. And I think even with the discussion that I heard from the last panel, I think it's when you focus on things like financial issues, and I'll get into this later, For smaller corporate interests, perhaps, we may agree that money may be more important than the ability to deal with other options for larger companies. Why do we care? Why do we care, or why does business care about this topic? When I was doing my undergrad in the 90s and after the Rio Declaration, and we were all kind of excited and focused on sustainability and sustainable development, as students you were learning, about the 3 R's, the reduce, reuse, recycle, and sustainability. What I like to teach my students and what we focus on with business and environment are what I call the 3 C's. That's cost, certainty, and compliance. And all 3 of those considerations are very much wrapped up into this topic in negotiating sentencing. Negotiated sentencing and creative sentencing. I regret I haven't been able to be here for the last day, so I know from seeing the program that there's been a lot of sessions that actually are delving into the detail of what this is. It's not my role to really dig into that detail, but for my purposes in preparing for today, negotiated sentencing would include things such as some of the newer kind of alternative enforcement mechanisms like EPAMs under federal legislation, the Environmental Protective Alternative Measures, where you're actually avoiding the ultimate kind of trial process, having been charged with an offense, and then sentencing after either guilty pleas or trials. So that's kind of where I've had my mind in preparing for today. We all care about this, and business cares about it, because obviously the trend is that fines and penalties are on the increase. I think there's been a lot of legitimate criticism, academically and otherwise, over many years that particularly comparatively with Canada and other jurisdictions, that our fines and penalties have been relatively low. You look at the Bata case from almost 30 years ago now, and the amount of time and resources that went into that case, dealing with both corporate and director liability for environmental offenses, and the $120,000 penalty reduced to $90,000 after an expensive 2-stage appeal, and director liability from 12 down to 6. And then you jump to Syncrude, where we're dealing with multiple millions of dollars, not necessarily directly analogous as far as the facts, and I'm going to come back to that topic. But obviously the trend is higher penalties, higher fines, and greater alternatives, all of which, from my perspective, when we're looking at negotiated sentencing, are entirely appropriate, and from a corporate perspective are appropriate. Whether you're looking at it from the polluter pays perspective, when you look at environmental law generally and broadly, environmental law being remedial in nature, and the principles of sentencing in environmental offenses, the deterrence aspect we've already heard about, deterrence and rehabilitation. Rehabilitation in the environmental context doesn't just rely on the polluter paying. In some cases, the polluter can't pay. We don't know who the polluter was. If you're connected to property, if we're dealing with offenses related to real property, even if you aren't the polluter, you may still pay. There's a lot of kind of broad considerations. We have the new federal legislation that's in force as of June 12, 2012, with the much higher minimum maximum penalties that are in place. So that's obviously a concern for business and corporate interests. Everyone wants to know what the parameters are. Everyone wants to know what they're dealing with. It comes into the certainty principle, comes into the cost principle, and certainly comes into the compliance issue. One of the goals, again, of any sentencing with the deterrence and rehabilitation, bringing the offender back into compliance with the law. I think we also care about negotiated sentencing and some of the issues that I know have been raised, on some of the pros and cons. Aside from costs, I think to some extent there's an access to justice issue. We all in the legal profession these days are talking a lot about access to justice, and I'll have some comments about that. I always pose the question, is it controversial? Or should it be controversial? I know some people see negotiated sentencing or alternatives as quite controversial. And in my own kind of research and looking at the issue, there seems to be some concern that increasing use of negotiated sentencing, settlements in that regard, or other alternatives to traditional compliance or enforcement present some kind of lack of transparency or a lost opportunity. Perhaps, I think this may tie into the question earlier, with respect to parity as an example. The lack of jurisprudence that gets issued. From my perspective on that issue, I think frankly it's an inherent kind of aspect to that process. Any negotiated settlement of any kind in law has to some extent, have a quid pro quo for those parties that are involved in it. From a corporate perspective, there are a number of pros or benefits to engaging in negotiated settlement. And one of those obviously is to avoid the full spotlight of a contested sentencing hearing before the courts and the public. I don't see myself the issue of the lack of jurisprudence, or at least the argued lack of jurisprudence, as a real issue or concern. And it comes down to some of the reasons that were given previously. We still have case law, we still have decisions that provide a fine or penalty or other measures that are put in place, and those cases will have a factual background attached to them. You may not have, from an analytical perspective from the bench, a decision that has to go through every kind of element or principle that would apply to sentencing in the environmental context. But you may not agree, but I think it's settled that the principles that apply to sentencing in the environmental context are pretty well settled. I think the courts have, for the most part, very much consistently agreed and applied the United Kino Mines case forward. Those sentences, the principles behind the sentencing are settled, as they should be. That provides certainty for all of the parties involved in this process. How those principles apply within a negotiation very much depend on the specific facts of any particular case. And so I don't think there's much precedential value necessarily in any event. You end up with a process, the principles are certain, you can look at the particular facts of a case. You may not get as much analytical detail, but to some extent, again, that's inherent, and it's a quid pro quo for the benefits of the process. I will say this from the corporate perspective. As lawyers, we may care that there's not a perhaps robust analytical framework. The clients don't really care about that. The clients don't care whether in not pursuing an appeal we are losing a transparent opportunity to deal with very interesting legal questions that are left unresolved. I'll get back to that. So I understand that as a lawyer, that reaction from my various clients. As a lawyer, privately I may be thinking, oh, wouldn't it be nice to That's a reality, frankly, that's not obviously just attached to this particular area of sentencing or area of law. It's something that's spoken about a lot in the civil litigation context with the growing use of mediation, arbitration, and out-of-court processes. So, I look at this very much from the underlying foundational legal principles are essentially set. We have clarity and certainty over that. We know what special circumstances the courts speak about with respect to environmental sentencing. Students raise various issues around, these concerns to me each year when I teach. And, as an example, in negotiating or taking advantage of broader alternatives, are we not essentially turning the system into just a cost of doing business? Purely just financial. And I would always direct them to the Alberta Court of Appeal as an example in R versus Toroco Industries, where very clearly, if there's any evidence of a corporate offender who has committed an environmental offense, simply as a cost of doing business, if that's an issue of concern, if there's any evidence of that, if that's the reality, then that is in fact an aggravating factor when looking at the whole issue of environmental crimes and sentencing. We can leave aside perhaps the discussion on whether a business or how they can write off for tax purposes or other after-the-fact issues on fines that are paid, but certainly if the concern is you're looking at from a corporate perspective, it's just a cost of doing business, just take the fine and pay for it. I think there's some very strong legal principles that would come to play to counteract that. I'm sure I'm not the only person after June 2010 when the Syncrude decision came out who has spent the last couple of years going to various conferences and listening to multiple presentations on this case. And it's an interesting case for very many varied reasons. But it's a very interesting case to look at from from exploring the corporate perspective. And again, kind of under this framework of cost, certainty, and compliance that I always like to think, to frame things from a business and an environmental perspective. And I think it illustrates some of the stuff I've already spoken about. And I would expect most of you are very familiar with Syncrude, and I expect it's probably been spoken about yesterday and maybe even this morning. Federal and provincial offenses being prosecuted together. Interestingly, and I don't know how many people know this, it was originally a private prosecution started by EcoJustice, so very interesting from an NGO perspective. We don't get I don't think, a lot of that happens in Canada, but it was ultimately taken over by the Crown in Alberta. A 9-week trial. Anyone that's involved in litigation, I'm exhausted just thinking about it. A 9-week contested trial where ultimately they were found guilty on all charges. And, again, a very interesting kind of plethora of different legal issues raised, all the standard kind of due diligence issues, the abuse of process issues with respect to the proceeding with both the federal and provincial charges concurrently. There's lots of academic writing that I've seen and kind of critique over this. Does that offend the rule against double jeopardy that's set out in Keen Apple? The defenses around officially induced error. All of those wonderful, interesting legal issues that were decided. And then, of course, Syncrude announces that it intends to appeal. And then changes counsel and takes a very different approach. And we end up with this negotiated settlement that somewhat kind of made the history books in the sense of, maximum fines under the federal and provincial legislation, the $300,000 and $500,000 fines, and then the additional penalties, the creative aspect of an additional $2.2 million put in place, allowing for various kind of creative remedial penalties, educational and remedial in nature for environmental projects and so on. All of the stuff that you would expect to see in that type of kind of creative solution. Now, why would Syncrude have agreed to pay both the maximum fines available under each statute and the additional $2.2 million? I think generally it's fair to say that the public reaction to the ultimate sentence was quite positive when you look at the reaction in the public. Leaving aside the legal issues that have been raised about lost opportunity in deciding some of these technical legal issues, was it an abusive process? Now we have, some people argue, a precedent that supports the ability of the Crown to proceed with these multiple federal provincial charges. I'm not too sure myself that that's necessarily, I don't think it's unique. I think we'll see more and more of that. My own view, having looked at it, is it's not improper. A bigger issue for regulatory lawyers and corporate lawyers like myself is this abuse of process or officially induced error, is the fact that your client, a corporate body that has is operating under a permit or license, the fact that they are then charged with a crime when they are not charged with violating the operating license or order, is that somehow an abusive process or an officially induced error? This was the whole kind of, does compliance with your license equal due diligence kind of argument, and does it bleed over into an abusive process when you're not charged with then violating the license? A lot of the academic commentary and discussions over coffee at conferences focused on those kind of unanswered legal issues. But again, Syncrude, a very large company, we can all assume has access to the greatest legal minds in the country. A 9-week trial, you can add that up in your own minds. An expensive appeal process, changes tactic and then seeks to negotiate. And from my perspective, it clearly comes down to the 3 C's. And the aspect around certainty, and perhaps with that you could define that C as control. This is a corporate offender at this point that's completely lost control of the situation, right? They've been found guilty on all counts. This is in a sector that already has a black eye in the view of the public, oil sands. The public is whipped into a frenzy, and they've clearly got 2 different kind of ways to continue to deal with it. The lawyers, I know, having spoken to them, would love to have continued to be able to deal with some of these interesting issues and resolve them. There's lots of commentary from people that would have liked that. However, their corporate interest necessitated a change. I don't think you have to be a rocket scientist to understand or agree with why they took that change in approach. I think it does, in some sense, perhaps highlight this difference between the smaller kind of corporate perspective or interest and larger corporate. I think you can look, just to kind of focus on this for a moment, the and if you look at the new minimum and maximum fines that have been put in place as of June 2012, you look at the table, right? It refers to small and essentially large corporations, and there's a big difference in the minimum maximum fines. Minimum 25,000 for the small and 100,000 for the larger, and then 2 to 4 million. That's on the summary convictions. And I would agree with the comments that I heard from our prosecutor friends. Smaller business interests, I think you can look at it from two perspectives. In many cases, and I know the people that I deal with may not be as sophisticated, may not have the financial resources, and so perhaps, but on the other hand, in many cases are more interested in just paying the fine and moving on. A small operator does not have the same corporate social responsibility, branding issues that a larger corporate entity may have. So they may be more willing to just pay the fine and move on, particularly if they are not one of these recidivist offenders we're talking about and don't have the intention to keep offending and then have to worry about the consequences of multiple convictions and offenses. The larger corporate interests, I think, are to some extent more interesting to look at with the growing use of negotiated and creative sentencing. And I find in my discussions with students and others that it's the perspective that causes perhaps the most concern for people who are not necessarily aligned to corporate interests, and plays into this concept of, well, it's just a cost of doing business. And what I mean by that is, as we heard, and I agree with, to some extent, money is not the issue for a Syncrude or a BHP, in the sense that whether it's a $2 or $3 or $4 million fine, they may agree to. There's no issue around bankruptcy, insolvency, or interrupting necessarily their business operations. And I know this to be a fact from the various clients that I deal with in that kind of size. These are corporate bodies who, particularly multinationals, they already have very robust environmental policies, compliance departments. They have a very defined structure leading right up through the organization. They're very concerned about compliance. These are not corporations that are blasé about environmental issues. And for many of those corporations, they have, over time, built this kind of corporate social responsibility brand of environmental kind of protection, which translates into financial issues, goodwill, and so on. You look at an Apple or a Body Shop or any of those, if they're going to be involved in some kind of environmental issue, they obviously have built up a certain brand and goodwill and corporate social responsibility. We can leave aside the discussion on corporate social responsibility. Is that just greenwashing? But it's certainly a consideration. So the ability to not just pay a fine, but to engage in a negotiation to put in place these various alternatives through creative sentencing is very attractive for those offenders, because it allows them, within dealing with the whatever has happened, the activity, the offense, to engage in the rehabilitation side of the equation. It's not just the issue around deterrence. It's the rehabilitation side. And also from a kind of industry sectoral side, we can look at the benefits that I think are significant in the alternative of just paying a fine. You look at the educational programs, you look at the environmental remediation programs that can be put in place. There's a clear benefit, and to some extent that's part of, from my perspective, the quid pro quo that may go into place, or the reasoning as to why a corporate entity would be willing to do that, than simply spend money that they can afford with their best lawyers to continue fighting these types of issues. Especially so when you have at least accepted responsibility for the activity up front and haven't spent a lot of time and money fighting the Crown to then change tax. So I think there's a mutual benefit that absolutely is there with negotiated sentencing and creative sentencing that goes far beyond just simply paying a fine. And again, I know, and I have them frequently with students, you can have the discussion around, well, is it still just a cost of doing business? Are we allowing these offenders to somehow inappropriately attempt to rehabilitate their own image in the public by seeking to be cooperative and working to, right the wrong? I would say what's actually wrong with that? I mean, isn't that part of what we should be doing anyway with the sentencing for various offenses, particularly in the quasi-criminal, the regulatory sphere? And again, latching onto the broader objects of environmental law, overall remedial in nature, not punitive. We see that phrase through various Supreme Court cases, and the sentencing principles, deterrence and rehabilitation. I also would argue that the ability to, and I think this goes into Peter's comments, which I strongly agree with, the ability to have that level of cooperation and discussion and input from the corporate offender in crafting the content of any creative sentence. As an example, one of the first cases, the Ashford Cleaners case from Toronto just a few months ago, that is under the new enhanced fines and penalties that are in place under federal law. Typical kind of dry cleaning operation, charged with improper storage, handling, and then release of perk. And they reached a negotiated settlement to pay a penalty, not a fine, of $60,000 to produce a series of articles, educational articles, that will be published in that industry's, that sector's business communications. I think that's a wonderful example of the use of creative sentencing. Than simply paying a $60,000 fine or less. You may have a media story. A lot of people would be like, well, it's dry cleaners. It's not an uncommon occurrence. But the ability to go beyond perhaps a media story and to really take some resources to educate others in that industry, in that sector, that would both, I think, have a deterrence and a rehabilitation impact. I think that's a good use of the system. I think it's a good use of those funds. And there are various examples that you can see in the case law where that kind of creativity is increasingly being used. So Syncrude, back to the question, why would they agree to the maximum penalties and an additional $2.2 million? And some people are very critical of that decision as well and have raised, interesting legal issues around the total monetary penalty. Is it in excess of should we be putting penalties that are so far in excess of the statutory maximum fines. Obviously now those fines have increased quite significantly to $4 and $6 million, but in any event, there's a reason why Syncrude, aside from the stuff we've been looking at and talking about, it was the strategy of the prosecution. When you, and this, you know, a negotiation, business, they know negotiation, right? They're business people, of course. So negotiation is a fact of life for business people, small and large. So it's a familiar territory for them. You're sitting down and negotiate a sentence. I would agree with the comments that I've heard. I would say that certainly I see a great willingness to engage in negotiation around sentencing for those parties that do find themselves in conflict with the law. But with Syncrude, as I understand it, and I had the pleasure of speaking with Kent Brown and Alex Bernard, who are the two prosecutors dealing with that case. They've spoken at a number of conferences. The threat was, and I use that word, that the prosecution would proceed as it is allowed to do under that legislation in seeking penalties as though each wildlife specimen was a separate incident or charge under the Act. So the wildlife legislation in Canada, this was the Migratory Birds Convention Act, but it also applies to the Wildlife Act and some other pieces of legislation, does allow that each particular specimen can be calculated for final penalty as if each one was the subject of a separate charge. So let's do the math. Maximum $300,000 fine under the NBCA for 1,606 birds, in excess of $480 million. Quite an effective lever to have in your negotiation around dealing with sentence. And I would suggest instructive as to why Syncrude would be so willing to agree to the maximum penalties, maximum fines, and such a high additional penalty. In, again, going into a negotiation and looking at what, you know, what's your worst and best, your worst case alternative, your best case. Even Syncrude's going to be worried about $400 million. That obviously wouldn't apply to the smaller corporate interests, and from that perspective, I fully agree with the comments that I heard earlier. Impecunious or corporate offenders that have minimal or no resources. I think creative sentencing does provide another avenue to meet the considerations that should go into play in sentencing for environmental offenses beyond just a dollar figure. So I think that can be used very creatively, and I think corporate parties generally are very open to that. So, I guess in concluding this, I don't see the use and the increasing development of creative sentencing and negotiated sentences in this sphere of environmental offenses as violating any principle that we can look at in environmental law, whether it's the broad remedial objective, whether it's the well-settled principles for sentencing of environmental offenses, deterrence and rehabilitation, It is consistent with other broader principles like the polluter pays principle in sustainability. I think, frankly, it is a realistic reaction to what is taking place within our legal system and community. Access to justice issues, the expense of litigation and the court process. I'm sure that Judge Curran, if he was here, would have some interesting comments or perspective on that. Public resources are precious, and if we have the ability to still use a process that respects the foundational principles while being creative and avoiding costly court and trial time, I think everyone benefits from that from a legal perspective. And again, from a precedential perspective, I don't see the concern that is raised with not having a plethora of reported case law dealing with how the sentences themselves are constructed. Excuse me. Though I recognize the arguments that are made, and I'm always happy to kind of debate that. But again, creative sentencing negotiation very much is in line with the corporate kind of issues around controlling the process and the cost, uncertainty, and compliance. And control certainly is something, to some extent, that goes beyond a dollar figure for corporate interests. When you head into court, as we all know, if you're engaged in litigation, you frankly never really know what's going to happen. Judges are human beings, like the rest of us, and you may have a good case, and you come out with a decision that obviously you don't expect, or vice versa. From a certainty and control perspective, entering into a negotiation, respecting the principles that are at play, and putting together some creative resolution from a corporate and business perspective is the way to go. I think we'll see increasing use of it, and rightfully so. That's my perspective.
Thank you very much, Sean, and thank you for filling in a sole session. It's going to be a double. I'll begin by asking if there are any questions from the floor or anything over the web yet. Yes, John.
Sean, I missed the third C. You said there were 3 C's, and the note that I took down was
Cost, certainty, and compliance.
Cost, certainty, and compliance?
Compliance, yeah.
I think the question was obvious from the answer. Well, it's okay. We had a couple of things come in. Sean, and one of the aspects that's been discussed with regard to the sentencing options has involved essentially public admissions of culpability in one format or another. Have you had any difficulty or experience in convincing clients that such an admission may be legitimate, may even be a positive opportunity in a sentencing arrangement? And does that experience differ between a larger corporate client where the personal investment in the firm may not be quite the same as a sole proprietor who identifies with the firm in a different way?
Yeah, that's an interesting question, and I think perhaps may apply differently in certain contexts. If you're dealing with creative sentencing or alternatives such as the EPAMs under federal legislation, well then there's no actual requirement to enter or put on the public record a guilty plea per se. You do have to, I suppose, admit or show responsibility for the actions that lead to the charge, but there's no requirement to actually on the record or publicly admit guilt per se. Yeah, I think there's resistance when you have those discussions with clients. Initially, every client, every person, for the most part, that's charged with particularly regulatory offenses that may be very technical, processes and so on. They may come to the table initially wanting to resist and oppose the charge, and will have, you know, their own technical responses. The concern around admitting guilt is something you do have to work through, but the requirement to admit or to take responsibility, perhaps that's the better phrase, to take responsibility in moving forward with a negotiated settlement. It's inherent. To some extent, it has to be done. I think if you're dealing with a prosecutor in negotiating a settlement or a sentence, if you've not challenged it and you're not dealing with having to go through a trial and then get a guilty plea, then obviously you've taken responsibility. That's not an issue. I think you're going to have a prosecutor perhaps who's going to be more concerned with how much leeway or what the extent of your negotiated sentence may be if there's clearly still a resistance to your client taking responsibility. So you definitely have to deal with that issue. Anyone that gets to the point of moving and entering into a negotiated settlement, I think, has to get to that point. If you don't, I would question whether you can actually reach a negotiated sentence if there's opposition.
And similarly on the issue of resistance, have you found or experienced any, if you've been involved in a case involving funds being allocated to NGOs, is there resistance to the notion of funds being allocated to some organization which on a daily basis might be seen as the opposition or the enemy to some extent?
Well, there might be. I think, frankly, there's less emotion about that aspect, particularly with larger corporations. I think it's easier for a larger entity, and as you said with the earlier question, who may not have the same level of personal or emotional interest, to see the benefits that are going to accrue from proceeding down this path than worrying about, oh, we're funding Sierra $50,000, etc. If you can craft the funding for all kinds of creative ways, Aboriginal groups, social projects, environmental remediation, educational, and I think what the company is going to be more interested in, this is part of the quid pro quo, in how they can then latch onto that and use it for their own rehabilitative purposes in the public eye. Yeah.
Anything else from, no? Yes, Al.
I'd like to ask you, in terms of a point that you concluded your presentation with, in terms of when the companies are negotiating the ultimate financial penalty, and this has been raised as an issue here, in terms of the lack of information, availability of information in terms of coming up with that final sort of financial penalty. Can you provide some insights, in terms of the factors and, and the difficulty associated with coming up with a range of offenses? I mean, for you as counsel, you don't necessarily have sort of the benchmarking that we have with other types of, let's say, criminal offenses.
Briefly, it's something that relates to the difficulty for counsel in crafting or participating in crafting a sentence with the lack of clear and straightforward benchmarks that are available in other types of offenses. Is that fair?
And I might kind of just elaborate a little bit in answering that as well, because one of the sentencing principles at play in environmental offenses, is this concept of disgorgement as well, of kind of, profit or benefit that may have accrued to the offender. That's the classic situation of thinking that somebody's, avoiding an expenditure, which then causes harm, and what was the benefit or profit. When you're looking at that issue or the kind of the benchmarking, from my perspective and experience, I haven't seen that to be as much of a concern. It really, I think Diane Sachs was here yesterday, right?
On video, yes.
By video, okay. You know, Diane's written some very interesting articles on this particular point, and I would agree with her perspective that, you know, these things are so fact specific to each case. I would question really the necessarily the lack of precedent. If you're looking at negotiating a financial fine or penalty, frankly, I think it's a harder job for the Crown, for the prosecution to be in, from an informational perspective. We know everything about our company and our client. This issue of disgorgement is another reason, frankly, why it's attractive for corporate offenders to take advantage of negotiated settlement, particularly for non-public companies. In control, this is the control piece I'm talking about, in keeping that aspect out of a contested sentencing hearing before the courts in a public forum, and a perhaps fully analysed decision. The ability to, again, keep control over that and to have those discussions privately in reaching a negotiated settlement is a very attractive for a corporate offender. But I mean, I acknowledge the issue. I don't see it as being a particularly critical one, and the benefits again of this process far outweigh those potential concerns.
One more.
Just one, I appreciate that. Sean, when in your experience or to your knowledge, a company is charged with a regulatory offense, and I'm not talking about failing to report this or that, I'm talking about maybe something a little more substantive, whether it's a pollution incident or, as Peter was mentioning, a Occupational Health and Safety Act violation where there's been a fatality.
That's a different context, yeah.
It's a different context, but what I'm trying to drive at is I'm talking about regulatory offenses at a more serious plane. Does the fact of the corporation being charged, and I'm talking about in the context of mid-sized to larger corporations, does it get the ear, to your knowledge or in your experience, of the directors of the company? Or is it dealt with at the kind of management operating level, just, well, we'll deal with it, we'll get the lawyers, we'll resolve the matter? Does it ever get, in your experience or to your knowledge, to the directors or the senior officers of the company?
Just to briefly summarize, the question relates to whether the sentencing issues and the discussion, negotiation, and the kind of impact on a corporation rises to the level of directors' concern and their attention, or primarily dealt with at the operational management level.
And the fact of the charge itself.
And the fact of the charge itself.
Yeah, it's a great question. It's going to depend on the severity of, I mean, every charge that a corporate entity may be subjected to, depending on the size of the corporation, obviously, is not going to go up the ranks necessarily to the CEO or the board of directors. A charge of some type that may be laid here in Nova Scotia for a multinational, you know, the CEO in Australia or wherever may not be spending any time or have particular knowledge of it. But I would say to you, for the most part, absolutely, because those larger corporations have such robust internal compliance structures. And because of the case law that has built up around dealing with environmental matters and having to have, these kind of growing layers of effective management and reporting and action, for the most part, I would say yes, if we're talking about the most serious. Certainly for the medium and smaller size, obviously. But from my own experience, absolutely. I've been involved in reporting and discussions to the senior levels of the company.
Okay, we're going to reconvene at
1:15.
1:15. I'd like to thank Sean for his presentation and for this participation in the discussion afterwards. Thank you very much.